This is a pre-hearing conference at Vancouver on the 25th of January 2010 concerning Jose Luis Figueroa. My name is Mark Tessler. We do have an interpreter present, but he's going to be on standby, not Mr. Kian. The Minister's Representative Sandra Turan. Mr. Figueroa, the Minister's requested a hearing in this matter, and what we have done is scheduled a conference to then look at dates when the matter can proceed. Now, you've received from the Minister a large package of documents. Have you decided whether you're going to get counsel for this hearing?
Well, first of all, I got to say that back in 2004, there were two decisions made on this case, on this matter. There was the pre-assessment removal
risk assessment.
Risk assessment. That was one thing, and we already had presented an application for exception on humanitarian grounds back in 2004. And on July 12, 2004, we were informed of both decisions. The pre-assessment that was on the conference or the hearing that we had for an immigration case. It was denied, but the exception on humanitarian grounds was approved by Officer King Hidalgo, and at that time we were still being represented by a lawyer. We was Peter Lowley. The person on that matter was his name was Crottenberg. I have to go through the papers. But anyway, at that time, when this was handed in to us, to my wife and I, the humanitarian grounds, the lawyer congratulated us in the matter that it was going forward. From that time on, we started getting mails from immigration requesting stuff like passport updating and stuff like this.
So you made an application?
Exactly. So the application had been going through, and we didn't see that we needed a lawyer since then. Yeah. So we haven't had any lawyers representing us in this matter, and so until the process has kind of been stuck in different stages. Back in 2004, it advanced. They were asking for different things, and we have documentation on like medical exams and stuff like that. Then on July 2007, they restarted sending us more requests about the medical exams. At one point it was already expired, so they requested more stuff in order to process this application. And they continue doing so, application for medical exams, renew passports, criminal checks, and all that stuff. Then the process of this application has been kind of stuck again until last year, when we received actually we never received a letter from Officer Ward Hinton. He called home, and I was working in Pastor Skull's farm, helping him. And then we received a call from him, and then he set up an interview with him on July 6th. That was when we had an interview. So to my surprise, there were so many questions relating my involvement with FMLN, and after that we received this review that he had made a report to the minister. To me, it has been kind of surprised because we have been here for 12 years, almost 13 now, and this is the first time that we hear about inadmissibility issues. Stuff that, on my opinion, they should have been dealt with if they had an issue. I have to point out, sir, that ever since I came into Canada at the border, I never lied about me having had a relationship with FMLN.
Okay, so
So
I
anyway,
understand you're not happy about this hearing.
no, it's not that. No, sir, it's not that I am not happy. My concerns is that there have been many years, and there's an issue that had come up that never came up before, and that's one of the main things that I am saying. And this is, I'm telling you that since 2004, we didn't think about having a representative of a lawyer. It was costing us a lot of money at that time. We paid about almost $5,000 in order to apply for the humanitarian grounds on lawyers' fee and stuff, so we didn't have any representation. I talked to the pastor in the church that we go, and we asked him to represent us in this matter. Because for me, it wouldn't be easy to represent myself if I don't have a background and to put it this way, my ideas about how the things have been going. Okay?
It seems to me, sir, is that
Sorry, your name, sir, is
Carl Keller.
Carl Keller.
I'm the pastor of
K-E-L-L-E-R?
K-E-L-L-E-R, Carl with K. And the letter in May in 2004 indicated that in 9 months this process would be complete as long as you provide these issues. So he provided those issues, except one, in that he had, he had to wait until his wife being pregnant was not allowed to have an x-ray according to the doctors. And so he wrote them back and said as soon as that the birth takes place, he would, and an x-ray would be allowed. That would be. Otherwise, all the information was done. What happened for those 9 months?
Yeah, well, everybody who applies for permanent residence has to go through a screening process. Part of the screening process is security screening.
Yes.
At some point along the way, obviously it's been recent, the minister has decided that in the minister's opinion, Mr. Figueroa is inadmissible on security grounds. So that brings the application for permanent residence to a halt until this issue is decided.
Okay.
And it's not decided by an immigration officer, it's decided at a hearing.
Yes.
And this is that hearing.
Okay.
So, the hearing is going to take place.
Sure.
The issues now that we're looking at is when it's going to take place and whether Mr. Figueroa is going to have counsel to represent him. And as well, if you look at the first package of documents, and you see it starts with it says volume 1. You find volume 1?
Volume 1, yes.
Okay, so if you turn to page 3.
No, you mean the page 3 or
Page 3.
it's a tab, that's the report.
Tab 3, page 3.
That's the report from there.
Yeah, that's the report. Now, if you read the report, it says So this is the allegation. So the minister is alleging that you're a foreign national who's inadmissible on security grounds for being a member of an organization that there are reasonable grounds to believe engages, has engaged, or will engage in acts referred to in paragraph 34.1c, namely engaging in terrorism. Now, it's the next paragraph that I think you need to look at. It says, the matter referred to in subsection 1 do not constitute inadmissibility in respect of a permanent resident of a foreign national who satisfies the minister that their presence in Canada would not be detrimental to the national interest.
Yes.
So I suggest to you that you also make an application to the minister for this exemption. Okay? It's under 34, 34.2, right?
Yes.
I didn't bring my application. It's 34.2?
No, I didn't bring my.
Sure.
But this is it's a separate matter. It's in a sense, it's like making a humanitarian and compassionate application. You have to make an application to the minister for an exemption.
So it will be different because we presented this back in July 2004.
Completely different.
It's totally different. Okay.
Totally different, and you have to apply under this section.
For exemption under which section?
34. Well, let me just go get my immigration legislation.
34.
Here, we're resumed here. So I just provided Mr. Figueroa and Mr. Keller with a copy of 34. Section 34, and which includes 34.1 and 34.2, which is the minister's exemption. So, you haven't spoken to counsel yet, to a lawyer about this proceeding.
No, he is my lawyer.
So you want him,
He will
Mr.
be.
Keller to represent you in this hearing? Okay. And Mr. Keller, you're not getting paid for this?
No,
Okay.
no. And I am not a lawyer, as you obviously know.
Okay.
I'm the pastor of a congregation.
Okay. So, it never hurts in these proceedings either to speak to somebody, to speak to a lawyer in advance, just so you can get an idea of how the proceeding will go ahead, and maybe to get a bit of advice. And you can often get that for free, you know. But in any case,
Does that mean we would go to legal aid?
you can call legal aid and see whether they'll assist. You could also call Mr. Larley and see if he could even just speak to him.
Continue on this matter.
Yeah, if you could just speak to him for a short while about it. Just some ideas about how to get some legal advice. So in any case, the way this works, it's like a little trial.
Mm-hmm.
So the minister has the burden of establishing that the allegation is true. The standard of proof is not very high. It's a standard called reasonable grounds to believe. So the minister has to establish the facts to that standard. So the minister is going to be presenting, obviously, this evidence, and it's been provided in advance to Mr. Figueroa, and also to this tribunal. The hearing can follow several in several different ways, but in general, if the minister isn't going to call any fresh evidence, they're not going to call Mr. Figueroa, the minister would just make submissions on the documents. Do you have any intentions with respect to your evidence? You're going to be calling witnesses?
I don't believe I'm going to be calling Mr. Figueroa at this time.
So you think you'll just be relying on your documents?
That's correct.
Okay.
So with regards with this, because we received all of these documents, and at no point, like there are kids involved in this, and the interest are in being or would be affected by a decision of the minister, and We don't see on this document referring to some conditions, like my son, he was diagnosed with autism back in 2002. Since then, my wife have been working with him. Like, I've been the only one providing for the family, and my wife has been taking care of him and at school, and we don't see much information about that.
Okay, so Mr. Figueroa,
Yes.
this is absolutely not a hearing regarding humanitarian and compassionate grounds to allow you to remain. It's simply, the hearing simply concerns establishing
The report.
the facts in the report.
Okay.
So the hearing is going to cover whether you're a foreign national
Mm-hmm.
and whether you were a member of an organization that there are reasonable grounds to believe has engaged or will engage in terrorism. Okay, so all of those membership, terrorism, organization, all of those are legal terms for which there's case law. The minister has to establish that all of those that the facts in your case fit into legal definitions of those of the language in the allegation.
Yes.
And then the member makes a decision. So your life in Canada, your family life, your work life, all of that's irrelevant for this proceeding. Okay. Now you can use as part of your application to the minister
So that he can sponsor.
for the exemption. For the exemption, yes.
Okay.
And I think it's very important.
Mhm.
I think that for that exemption application, you may really want to get a lawyer to assist you to prepare that application. If you're not going to use a lawyer for this proceeding, but at least for the exemption application, because it's going to be they're going to write a letter to the minister.
Yes.
Okay, so it's going to contain information. So you want that. You want to get the right information before the minister.
Yeah, because referring to the report, analyzing this, Mr. Washington, he made so many statements, as for instance, that myself, I am a foreign national who has not been authorized to enter into Canada. And back on May 2004, actually we arrived to the border with Canada, and we were provided 1997. Yeah, sorry. Back in 1997, when we arrived into Canada, we got to the border. We made the application for the refugee claim that we made there. Then we were returned back to the States, where we stayed for some days until May 6th. On May 6th, they issue a document that authorized us to enter into Canada for further examination. And in this case, I'm trying to see, he is stating that I was not authorized to enter Canada. There are documents that indicate that yes, we were authorized to enter
Okay,
Canada.
well, I'm sure in that issue, the minister will have a response, okay?
Okay.
So I don't want to get into issues of substance here today. All I would like to do is come up with a date when you believe you'll be ready to proceed, okay? So, generally what we do in these pre-hearing conferences is we find out whether the person wants counsel, whether they've made any arrangements for counsel. So in this case, Mr. Figueroa, you've decided to proceed with Pastor Keller to assist you. So I believe at this point we can just come up with a date. It'll have to be sometime in March after the Olympics, because we're not doing any of these kinds of hearings during the month of February.
Okay.
So,
Yes, we are very interested into getting into this as fast as we can.
Yeah.
You know, because we have been here for
yeah,
a
we've
long
been
time.
here since a long time.
Yes.
Okay,
You
so
said
let's-
excuse me, you said that to get this information for the exemption, that takes a long time.
No, the actual decision of the minister tends to take a long time.
Okay.
Yeah, so
What is the time frame for?
I can't really tell you. I just know that you should get the application started as soon as you can. So,
Should we wait for an answer from the minister before we have the hearing?
well, I can tell you that the minister will contest that
That application?
That application. So, in general, we don't give adjournments to wait for that application. However, I have seen decisions, and I've made some decisions myself, granting an adjournment, but the circumstances have been very, very specific, very particular. Again, I suggest that you go speak to legal counsel about this, just so that you understand a little better the framework. If you want to make that, if you want to make an application for an adjournment, then we can do that. We can hear that at the opening of the hearing, and the member will consider it. But again, I suggest that the minister will oppose that application. So let's take a recess here and come up with a date to open the hearing.
Just so that before we take a recess, the minister has made this disclosure mostly what he will be relying on. However, there's going to be one more set of documents that are going to come, and that's just case law, and that'll be made available to all parties well in advance.
Okay.
So.
Okay, this matter is resumed. So this hearing is scheduled for the 22nd of March, which is a Monday, at 9 a.m. And we'll set aside the whole day for it, so 9 to 4, and we'll try and get it completed on that day. If anything changes, if you find you want to have counsel, you should advise the Immigration Division and Ms. Duran as soon as possible, so that if the date needs to be changed to accommodate counsel, something like that, just let us know as soon as you can, okay? But otherwise, we'll expect the matter to proceed on the 22nd of March.
Okay, great.
Okay, this conference is concluded.